think those are all the questions? Yeah. Are there any other members of the public who haven't addressed us yet and want to? Okay. Why don't we start by seeing if there are any questions of staff? Members of the Community Council, this does not mean consulting your Blackberries. Are there any questions of staff? Councillor Vaughan.
One of the concerns that has been expressed to us through interested parties is that if we consent to a series of height regimes along major streets, that the OMB will see that as a consent to those heights, and therefore they will be de facto as of right, rendering Section 37 agreements null and void, in fact, even unnecessary. What is the thinking of city legal and planning on that issue? Because if this wipes out density and height bonusing in the downtown core, it puts the city in a very strange position vis-a-vis a significant number of capital programs underway right now.
Well, through the chair, that is certainly not the intent of this exercise. The exercise is to put in place a set of performance standards for how you do tall buildings downtown, and to articulate a vision of or a planned context for future height for downtown on high streets and secondary high streets. The consultants had certain recommendations in their report for 37 that were not entirely in line with the citywide process and protocols for 37, and staff have not brought forward a new regime for Section 37 in this report. We are not putting any recommendations forward to Community Council about Section 37 in this report. And,
but if
it's business as usual, in my view, in terms of Section 37.
But if the underlying zoning exists at, for example, on parts of King Street about 23 meters, and this new height regime says effectively that up to 100 meters is as of right, how does the Section 37 then get calculated? If you have one city document saying that it's as of, virtually as of right within these, with these conditions met, does that not attach to the property the argument that the city has consented to accommodate this sort of height and density on this site within certain parameters?
In my view, it's a package. You have to deal with the applicable official plan policies, the guidelines that might apply. If you're in St. Lawrence, you would also have to consider the St. Lawrence guidelines or Yorkville guidelines. It in no way establishes a new base to consider a new basis for calculating the Section 37, because there are so many considerations that have to be taken into account to determine the value or the merit of a rezoning application.
What page of the report spells out that legal argument?
Well, I mean, again, we didn't bring forward any recommendations for Section 37.
I appreciate
happy
that.
to provide that clarification if
that clarification is not part of the policy nor embedded in this motion.
What's applicable is the official plan policies that apply citywide and in the downtown.
But it's not embedded in this report.
There is a discussion about Section 37, but if you want, Councillor, we can certainly provide a clarification on that point.
The study, this report is intended to only talk about buildings being proposed in the study area identified on page 1 of the staff report here.
Yes.
And so it's not meant to deal with applications that might appear along the Danforth or further up Yonge Street or further along Bloor Street.
No, it's focused on the 3 downtown wards.
Those areas would still be governed by the existing tall building guidelines.
That's correct.
Right. And so the arguments that two-story structures at subway stations, which, except for Bloor and Yonge, don't really exist much in the downtown, that argument is outside the study area, and therefore these guidelines explicitly would not govern those properties.
That's correct.
Okay. In terms of the streets that are captured within the study area but aren't given any particular designation, I noticed that Yonge Street has a very particular set of conditions or study requirements assigned to it. Would it be fair to assign those sorts of conditions to other boulevards that are experiencing growth pressure, for example, Spadina Avenue?
We have discussed that with your office, and certainly Spadina, given its right-of-way width and unique attributes with the streetcar, has a special character. There's no doubt it does. We took this as far as we did with Yonge Street simply because of the consultations that we've been having and the further work that we're doing in that area on Yonge Street. And we've tried to articulate an initial vision for Yonge Street that deals with the pedestrian scale of Yonge Street and the pedestrian scale of the built form, allowing some accommodation for tall buildings if and where it's appropriate.
Okay.
And same type of thinking process could be applied to streets like Spadina.
And since on many of these significant boulevards, for example, I don't think I've seen a 10-story building except in residential neighborhoods in my ward. It's certainly not on the main streets. On those main streets, where all we get are 100-meter, 120-meter buildings, because we are effectively creating these avenues as we speak, with or without this policy, what would the advantages, what possible advantages might there be to a permit pulling system as opposed to a Section 37 negotiation system to say you can reach certain heights on these streets within these defined guidelines, but the following criteria must be met, and some of those criteria could include internal dynamics as opposed to simply architectural dynamics on the outside. In other words, we heard a number of deputies talk about the need to preserve commercial space. We know that there's a push on to protect family space, to create affordable housing inside some of these areas. Could a permit pulling system actually mandate diversity inside the buildings as a way of creating growth and dynamics on the outside of the building?
Well, I can try and help you with an answer there. It's certainly the Planning Act would permit the use or development of a permit system in Ontario. Very few municipalities have availed themselves of that, and it involves setting up an entirely different kind of approval process. It would look at kind of collapsing or combining the various approval processes and considerations that you're used to here, be it committee of adjustment and rezoning and site plan approval and all the other things that are required, into a different kind of system, which again, maybe it was discussed, can't remember, maybe 10 years ago in the City of Toronto, but we've never really have gone there in terms of understanding it more fully or building the apparatus that would be required to support it.
But we could, for example, as well build heritage considerations into that process as well. So instead of facadism, we could actually get a much more robust heritage strategy built out of this as well.
Again,
it's
an alternative system. I'm not an expert on it, so the extent to which you can add in various attributes, it's something we could look at, but it's not something that we're equipped to deliver today, certainly.
Okay, and just finally, I appreciate the indulgence from City Legal.
I indulged you.
I appreciate that. It's Valentine's.
Yes.
With a feather boa like that, how could you say no? But but with the issue about whether the OMB would read these new height designations as implied consent, would it present a problem at the board for us, and has it already, in fact, presented a challenge for us?
Madam Chair, Mr. Chairman, through you, I guess I would point out that, technically speaking, under Section 37 of the Planning Act, what Section 37 benefits are provided for is where there's an increase in height or density above and beyond what is otherwise permitted in the zoning bylaw. And therefore, the starting point is what is currently permitted in the zoning bylaw as opposed to guidelines. So my reply would be that what the Ontario Municipal Board should be looking at is the base point of the underlying zoning bylaw as opposed to any guidelines.
As part of the calculation of 37.
Correct.
But they could approve the building because of the implied consent as being virtually as of right as a result of these guidelines, if they've met the guidelines.
Well, the point is that they are guidelines. They're not official plan policies, and they're not zoning standards.
But they're already being argued with. I mean, they've already been presented as evidence at the OMB in front of this application being presented to us. They were FOI'd by an applicant, and they've been used to effectively gain approval from the OMB even before City Council had them tabled.
They certainly would be used.
They already have been used.
Yes.
The city's used them, and applicants have used them, and have enforced them through the OMB already.
Well, the starting point under Section 37 is the underlying zoning.
Implied under, okay.
We may indulge you with a second round if we get there. We'll see. Councillor